Most people think an eviction means the police show up one day and throw someone out immediately. This is not how the process works, especially in Rhode Island and Massachusetts. Today, I'm going to explain what actually happens during an eviction, what landlords and tenants need to know, and how understanding the process can help both sides avoid expensive mistakes. I'm Luca, Realtor, and my goal is to help people make informed real estate decisions with clarity, professionalism, and respect for everyone involved. So what exactly is an eviction? An eviction is a legal process through the court system that allows a property owner to regain possession of a property when a lease agreement or rental obligation has been violated. In Rhode Island and Massachusetts, landlords cannot legally remove tenants themselves by changing locks, shutting off utilities, or removing belongings. Those actions can create major legal problems for the property owner. An eviction usually begins because of non-payment of rent, lease violations, expired leases or holdover tenants, property damage, illegal activity, or repeated disturbances or nuisance complaints. One of the biggest misunderstandings that that an eviction is an instant event. In reality, it often takes weeks, sometimes months, depending on the circumstances, court scheduling, and whether the tenant contests the case. The notice stage, the first step, is usually a formal written notice. Make sure you document everything. The exact notice depends on the reason for the eviction and state law requirements. For example, a non-payment notice may provide a tenant with a specific amount of time to pay rent owed. A lease violation notice may provide time to correct the issue. Now, some notices just inform the tenant that the tenancy is ending. This is one of the most important parts of the process because improper notices can delay or even dismiss an eviction case. That's why landlords should work closely with a qualified real estate attorney or property management professional instead of relying on internet advice or social media. Court process. Now, if the issue is not resolved after the notice period, the landlord may file an eviction action in court. At that point, a court date is scheduled. Both sides can present evidence, and the judge reviews the leases, notices, payment history, and other documentation. The court does not automatically side with either party. Documentation matters. This is why landlords should keep signed leases, payment records, written communication, inspection reports, photos, and notices. Just note to yourself, take pictures of the property before the tenant moves in so you can document the condition in which it was delivered to the tenant. Now, tenants should also keep records of payments, maintenance requests, communications, and lease documents. Everything matters more when it's in writing. If it's not in writing, it doesn't matter at all. The legal system works best when facts and documentation are clear. Now, what happens after the judgment? If the court rules in favor of the landlord, the tenant is typically given a time frame to leave the property voluntarily. If they don't leave, the court process may continue forward, and it may include physical removal through law enforcement or authorized officers, not the landlord personally, or not the property manager. Now, again, this is why self-help evictions are extremely dangerous legally. It's also important to understand that evictions can seriously affect a tenant's future ability to rent housing, obtain financing, or pass tenant screening in the future. How do you avoid evictions? Well, the best eviction is the one that never happens. For landlords, prevention usually starts with proper tenant screening, clear lease agreements, consistent communication, thorough documentation, prompt maintenance, and professional management practices. Folks, pay attention. If your tenants they speak a language where English is not their native language, it would behoove you to put the documentation, including the lease, in the language in which they are comfortable. For tenants, avoiding eviction usually means communicating early if financial hardship occurs, understanding the lease before signing, keeping records, and responding to notices immediately instead of ignoring them. In many situations, communication and professionalism can solve problems before they even become legal disputes. All right, if you found this video helpful, please subscribe to my channel, Rhode Island Real Estate with Joe Luca, where I break down real estate topics in plain English so buyers, sellers, landlords, and tenants can make smarter decisions. I also host the Joe Luca Real Estate Show, which is on every Tuesday evening on WNRI. You can check it out at WNRI.com. Drop your questions in the comments because future videos may come directly from your questions. And remember, informed decisions usually lead to better outcomes for all involved. Now, next I have an FAQ section. This is something I'm just starting, so here we go. Number 1, can a landlord change the locks immediately? No. Landlords generally cannot legally change the locks without following the court eviction process first. Self-help evictions may violate landlord-tenant laws and create serious legal liability. 2, how long does an eviction take? An eviction can take anywhere from several weeks to several months, depending on the circumstances and the court schedule. Contested cases usually take longer. 3, does an eviction hurt a tenant's record? Yes. An eviction can negatively affect future rental applications and tenant screening reports. It may also impact credit or future housing opportunities. Question 4, can a tenant stop an eviction? Sometimes a tenant may stop or delay an eviction by correcting the issue, negotiating, or defending the case in court. The outcome depends on the facts and applicable law. Question 5, should landlords hire a lawyer for evictions? Yes. Landlords should strongly consider working with a qualified, experienced attorney familiar with Rhode Island or Massachusetts landlord-tenant law. Errors in notices or procedures can become expensive. If you have any questions, comment below. I'd love to hear from you. Take care, everyone. Bye-bye. Take care. Bye-bye.